The number is 93%. That figure is published by The Guardian's data team on the morning of February 11th, 2026, after 11 months of records requests, 4 federal lawsuits to pry loose redacted spreadsheets, and a cross-reference of 412,000 individual ICE arrest entries against the Department of Homeland Security's own internal demographic logs. 93 out of every 100 people arrested by Immigration and Customs Enforcement between October 1st, 2024 and November 30th, 2025 are identified in DHS's own coding as Hispanic or Latino. The national undocumented population, by DHS's own most recent estimate, is roughly 71% Latino. The gap between those two numbers is 22 percentage points. That gap is what the lawsuits are about. Inside ICE headquarters at 512th Street Southwest in Washington, the response is immediate and procedural. A 7:40 a.m. all-staff memo from Acting Deputy Director Madison Sheehan tells field office directors to refrain from public characterization of the methodology and to route all press inquiries through the Office of Public Affairs. By 9 a.m., the memo has leaked. By noon, it is on 3 cable networks. By the end of the day, 93% is trending in 4 languages. This is the story of how that number was assembled, who tried to bury it, and what a federal judge in the Southern District of California does with it on the afternoon of May 14th, 2026. Begin with the data itself. The Guardian investigation is led by reporter Manvi Singh and data editor Aliyah Utiova, working alongside a coalition of legal defense organizations, the American Immigration Council, the ACLU of Southern California, and a smaller Houston-based nonprofit called Raices Legal Aid. The coalition does not start with a hypothesis. It starts with a question raised by a single public defender in San Diego, Elena Marquez, 38, 11 years on the federal Indigent Defense Panel, who notices in late 2024 that every single one of her ICE detained clients that month shares a country of origin within the same hemisphere. She runs the numbers in her own caseload. 41 for 41. She writes a memo to her supervisor. The memo goes nowhere, so she sends it to a reporter. That is how investigations begin, not with a leak, with a spreadsheet on a public defender's lunch break. The data the coalition eventually obtains is not one file. It is 43 files, spread across 9 DHS subcomponents, requested under the Freedom of Information Act over a 14-month period, and partially released only after a federal magistrate in D.C., Judge G. Michael Harvey, orders DHS to comply with a court-approved production schedule on August 22, 2025. The released material runs to 2.1 terabytes. Most of it is operational chaff, vehicle logs, fuel receipts, daily briefing PDFs. The valuable core is a single relational database called EAGLE, the Enforcement and Apprehension Geographic Log Engine, which records every arrest by date, location, agent badge number, statutory basis, and self-reported or officer-identified ethnicity. EAGLE is where the 93% lives. The obvious question is whether 93% simply reflects who is in the country without authorization. DHS's public position, laid out at a February 12th press conference by spokesperson Tricia McLaughlin, is exactly that. The arrest demographics mirror the undocumented demographics. The math, she says, is unremarkable. The coalition's response, filed in court 2 weeks later, is a 184-page brief that does the math out loud. If the undocumented population is 71% Latino and the arrest population is 93% Latino, then Latino individuals are being arrested at roughly 1.31 times the rate predicted by population share alone. In raw numbers, that means approximately 90,000 of the 412,000 arrests in the 14-month window cannot be explained by demographic baseline. They have to be explained by something else. Something else is what the lawsuits are trying to name. The legal theory is built around the 4th and 14th Amendments and a 1975 Supreme Court case called United States v. Brignoni-Ponce, which holds that apparent Mexican ancestry, standing alone, cannot establish reasonable suspicion for an immigration stop. For 51 years, Brignoni-Ponce has been the floor. The coalition argues that Eagle shows the floor has collapsed. They point to specific operational patterns: arrests clustered at Home Depot parking lots in Phoenix, car washes in Nashville, agricultural distribution centers in Bakersfield, and the loading docks of 2 specific food processing plants in Worthington, Minnesota, and Cactus, Texas. The clustering is not random. The clustering is the case. Think about what that means. An algorithm is told to optimize for productivity. Productivity is measured in arrests per shift. The fastest way to maximize arrests per shift is to go where the targets are densest. The targets, by demographic baseline, are densest in Latino-majority work sites. The algorithm does what algorithms do. It optimizes. That is the coalition's theory. The government's is different. DHS's filings, prepared by Justice Department Civil Division Attorney Daniel Schwei, argue that ICE's targeting is driven by 3 lawful inputs: outstanding final orders of removal, criminal warrants flagged in the National Crime Information Center database, and tip-line referrals from local law enforcement. Schwei's brief, filed March 6, 2026, runs to 211 pages and includes 38 sworn declarations from field office directors in San Antonio, Atlanta, Newark, Los Angeles, and Chicago. Each declaration insists the same thing. The agency follows leads, not demographics. The leads simply happen to point where they point. The judge assigned to the consolidated case is Cynthia Beshant, a 2014 Obama appointee, 64 years old, a former federal prosecutor with a reputation for reading every footnote. She schedules oral argument for May 14th. Between filing and argument, the picture on the ground gets worse. On March 19, 2026, an ICE enforcement and removal operations team in Phoenix arrests a 47-year-old U.S. citizen named Hector Ramirez outside a Lowe's on West Camelback Road. Ramirez is held for 19 hours at the Florence Service Processing Center, 63 miles south, before a supervisor confirms his Arizona driver's license is legitimate. ICE releases him without explanation. His attorney files a Bivens claim within a week. The arrest report lists the basis for the initial stop as consistent with subject profile. That phrase appears 1,847 times across the Eagle database. It has no statutory definition. On April 2nd, a second wrongful detention surfaces in Nashville. A landscaper named Joel Mendoza Castillo, in the country on a valid H-2B visa, spends 4 days at the LaSalle ICE Processing Center in Jena, Louisiana, before his employer's lawyer locates him. His visa documentation is in the truck the officers searched. They did not look at it. On April 11th, a 19-year-old DACA recipient named Brianna Olivares is arrested outside Lincoln Tech in Mahwah, New Jersey, held for 31 hours at the Elizabeth Detention Center, and released only after her congressman's office personally calls the field office director. 3 cases in 23 days. None of them are statistically meaningful by themselves. All of them are added to the coalition's brief as illustrative exhibits 14, 15, and 16. The coalition also has a witness no one expected. His name is Brandon Holcomb, 41 years old, a former ICE Enforcement and Removal Operations Supervisor based in San Diego, who resigns on January 30th, 2026, and signs a sworn declaration on April 4th. Holcomb states that during his final 18 months on the job, his unit was given daily quota targets, not officially called quotas, but referred to as operational benchmarks, of between 75 and 110 arrests per week per team. He states that when teams fell behind benchmark, supervisors were told to deploy to what internal communications called high-yield zones. He provides screenshots. The screenshots show map overlays. The overlays correspond almost exactly to census tracts where Latino residents make up more than 60% of the population. Holcomb's declaration is the document the government most wants to suppress. They moved to strike it on April 18th. Judge Bashant denies the motion on April 29th in a 2-page order that uses the word germane 4 times.
You might wonder why ICE leadership doesn't simply change the targeting criteria the moment the data goes public. The answer is that they cannot, not easily, because the targeting criteria are not a single document. They are an accumulated layer of operational guidance, field office discretion, third-party vendor contracts, and a $3.4 billion data services agreement with a company called Palantir Technologies, whose Gotham platform feeds directly into Eagle. Changing the targeting criteria means renegotiating contracts, retraining 7,800 ERO officers, and admitting in writing that the prior criteria were defective. None of those things happen on a 30-day timeline. So ICE does what large agencies do under pressure. It issues a memo and waits. The memo, dated April 22nd and signed by Acting Director Caleb Vitello, tells all field offices to ensure that ethnicity is not utilized as a primary or sole factor in enforcement targeting. The phrase primary or sole is the load-bearing language. It allows ethnicity to remain a contributing factor. The coalition's lawyers read the memo within an hour of its release. They add it to the record as Exhibit 41. May 14th, 2026. San Diego Federal Courthouse, Courtroom 4B. Oral argument begins at 1:30 p.m. Pacific. The government's lead argument is presented by Schwei, who stands at the lectern for 41 minutes and does not concede a single percentage point. He insists the 93% figure is a function of geography, demography, and lawful enforcement priorities. Bashant interrupts him 11 times. One of those interruptions becomes the quote that runs in every newspaper the next morning. "Counselor," she says, leaning forward, "if your geography argument is correct, then your geography is itself the problem. Help me understand which one of those you are conceding." Schwei does not concede either. The coalition's argument is presented by lead counsel Ahilan Arulanantham, 53, a MacArthur Fellow and longtime ACLU litigator who has argued before the Supreme Court 4 times. He speaks for 36 minutes, no slides. He walks the judge through 3 specific arrests: Ramirez, Mendoza-Castillo, Olivares, and then, at minute 28, he projects a single map of San Diego County onto the courtroom screen. The map shows Eagle arrest density overlaid on census ethnicity data. The 2 distributions are not similar. They are identical. Bashant takes the matter under submission at 3:47 p.m. Her ruling lands 7 weeks later, on July 2nd, 2026, at 9:15 a.m. It is 78 pages. It grants a preliminary injunction. It orders ICE to suspend the use of any targeting algorithm or operational benchmark that relies directly or indirectly on geographic proxies for ethnicity
pending full adjudication on the merits. It does not shut down ICE. It does not free anyone in custody.
What it does is unplug a specific input from a specific machine and require the agency to document, in writing, every targeting decision made for the next 180 days. The agency complies. Slowly. Imperfectly. With 3 motions for clarification filed in the first month alone. Here is the part the ruling cannot fix. The 412,000 arrests already happened. The roughly 383,000 Latino individuals already detained, processed, deported, or released have already lived through whatever they lived through. The injunction is prospective. It is not a refund. The system worked exactly as designed. That's the problem. In the months that follow, the data story spreads. The Cato Institute publishes its own analysis on July 19th that reaches an even higher figure, 96%, for the subset of arrests categorized as collateral, meaning individuals encountered during enforcement actions targeting someone else. The Migration Policy Institute issues a 44-page report on August 3rd, documenting parallel patterns in 5 state and local 287G partnerships. A bipartisan group of 17 House members requests a Government Accountability Office audit of EGLE itself. The audit opens on September 9th. Results are not expected until 2027. The Palantir contract is the next domino. On August 22nd, the House Homeland Security Committee subpoenas the full text of the Gotham Services Agreement, all 1,840 pages of it, including the targeting logic appendices that DHS has so far refused to share even with congressional staff under standard security clearances. Palantir's general counsel testifies on September 14th. He uses the phrase, "We build the tool, we do not direct its use," 11 times. The committee is not satisfied. Across the country, individual immigration judges begin citing the Beshant ruling in their own dockets. A judge in Atlanta suppresses arrest evidence in a removal proceeding on August 11th because the underlying stop was based on a high-yield zone deployment. A judge in El Paso does the same on August 26th. By the end of October, at least 47 removal cases have been dismissed or remanded on related grounds. The number is small relative to the 412,000. It is not small relative to legal precedent. Inside ICE itself, the effect is harder to measure, but real. Internal surveys leaked to Government Executive magazine in October show ERO officer morale at its lowest recorded level. Resignations in the deportation officer track rise 18% year over year. Recruitment for the 2026 Academy class falls short of target by 412 candidates. The agency authorized to enforce immigration law is, by its own internal metrics, struggling to staff itself, and the 93% figure does not move. Subsequent quarterly EGLE polls, conducted by the coalition under the court's continuing oversight, show the ratio at 91% for the December to March quarter and 89% for April through June. The needle bends. It does not break. Return now to where this began. 4:17 a.m. Central Los Angeles. The white Ford Transit on Cesar Chavez Avenue. The tablet with the wrong names. By the time Judge Beshant signs the injunction in July, the 2 men inside that stucco duplex, brothers, both legal permanent residents since 2003, both employed for over a decade at the same restaurant supply warehouse on Olympic Boulevard, have been deported to Guadalajara, returned to the United States after a successful motion to reopen, and finally relocated to a different neighborhood entirely. Their attorney, a 34-year-old immigration lawyer named Sofia Reyes, keeps a printout of the EGLE arrest entry that listed their address on her office wall. The line reads,
Basis for encounter, consistent with subject profile. That phrase, the one that appeared 1,847 times in the database, is now legally meaningless. The brothers' arrest record is still legally real. The story of the 93% is not the story of a single raid or a single ruling. It is the story of what happens when an enforcement agency builds a machine to find people, and the machine works, and then someone counts. A public defender on her lunch break. A data editor with 43 files.
A supervisor who quit and signed his name to a declaration. A federal judge who used the word germane 4 times in a 2-page order. None of them stopped the machine. They documented it. The documentation became the case. The case became the injunction. The injunction became a new line in the Eagle database that now reads, in field 47 of every new entry, justification narrative required. That field is mandatory now. It was optional before. Somewhere in San Diego, in a 4th-floor office in the federal courthouse on West Broadway, the printouts of the 412,000 arrest entries sit in 17 bankers' boxes along the back wall of a clerk's storage room. They are evidence in an ongoing case. They will be there for years. They are, in a very specific sense, the largest single audit of American immigration enforcement ever conducted. And they exist because one public defender, one morning in late 2024, decided to count. 93%. That is the number that built the case. It is also the number that, 4 years from now, lawyers in courtrooms in Phoenix and Atlanta and Newark and Houston will still be citing, in cases not yet filed, on behalf of clients not yet arrested, by an agency still trying to figure out what its targeting criteria are allowed to be. The machine is still running. It just has to write down what it does.